Good afternoon, everyone. Thank you for joining Orleans PCs for today's webinar, Avoiding the F Word, Alternatives to Commercial Mortgage Foreclosure. My name is Connie Kinzer. It is my pleasure to introduce our esteemed speakers for today, attorneys Julie Moran and Regina Slowey. Julie is Senior Executive Counsel for Orleans PC. Ms. Moran has more than 25 years of experience in commercial real estate, including mortgage workouts and foreclosure. She began her career with a large real estate law firm in Boston, Massachusetts, where she regularly represented financial institutions and developers in multi-million-dollar loan and workout transactions, including lease negotiation, sales transactions, secured and unsecured loan closings and workouts, suits on notes, and guarantees. Julie is an attorney agent for the First American Title Insurance Company and serves on the board of directors for the Massachusetts Real Estate Bar Association. She is co-chair of the Financial Services Litigation Committee of NAMWOLF and chair of the Legal Issues section of the USFN. Regina is the managing litigation attorney for Orleans PC. Ms. Slowey has over 20 years of litigation experience, specifically devoted to business and real estate litigation involving the mortgage and lending industries. She has also been involved in the title industry for over 15 years, working with realtors, agents, and underwriters. Attorney Slowey manages the title, collection, and litigation areas of practice throughout 8 states. She loves to share her expertise at training seminars, conferences, and continuing education courses on real property law and related topics. We turn it over to Julie.
Thanks, Connie. On behalf of the Orleans PC Commercial Loan Default Group, I welcome you to the first in a series of webinars on commercial loans. In the coming weeks, our seasoned group of attorneys in our 10 states are going to cover such topics as business loan defaults. We're actually going to deep dive into a foreclosure process. We're going to talk about bankruptcy, Chapter 11s particularly. We're going to talk about receivership. And then finally, we're going to round it out with a discussion about distressed properties and loan restructuring. In our more than 25 years of assisting clients in residential and commercial loan defaults, this is certainly one of the most uncertain times we've ever encountered. Our clients are now finding that unlike the beginning of the pandemic, as we move into the end, as we evolve out of the pandemic, they can no longer adopt a wait and see attitude, kicking that can down the road to a other solution, shall we say, as losses accumulate and pressures increase to resolve these loans has just become a non-starter. Our discussion today has a catchy title, but it's a really important topic. What are the options other than foreclosure to resolve a commercial real estate mortgage loan? I'm going to kick off the discussion to talk about foreclosure avoidance options. When do we allowing the borrower to retain the property while either resolving the loan or returning it to a performing state? Then I'm going to turn it over to Regina, who's going to talk about what happens when the option really is the only option in these cases is to liquidate the real estate loan. Next slide, please. Why avoid foreclosure? From the lender's perspective, it's really basic. There are other more efficient, more effective remedies than foreclosure. And again, it's always about time, money, and risk. Let's talk about time. If it's a judicial foreclosure process that you need to pursue in your state, it can take 18 months, up to 2 years or more. You can have a bankruptcy that may intervene that can delay it. Court delays are inevitable, particularly right now during the pandemic and its aftermath. You can obviously have challenges from the borrower, from another junior lien holder that can also extend the time to complete the foreclosure. And then it's about money. Foreclosures are expensive to pursue to closure. You may need to invest money to make the property market ready once you foreclose. Your asset, as you're sitting waiting for the foreclosure process to conclude, can deteriorate. Value, fire sale of a foreclosure means a lower return to you and then ultimately to the borrower if there's any excess left over. Carrying costs are extensive on a commercial property. Taxes, insurance, maintenance costs. And then, of course, the biggest risk is, as you're moving through the foreclosure process, is the type of risk that you're going to be presented with. First of all, you're stepping into the shoes of the owner once you foreclose. You're dealing with tenants. You're dealing with non-disclosure and attornment agreements. You're dealing with property conditions, municipal violations that can take priority over your mortgage. You may have lease impairment. You may have tenant eviction, tenant bankruptcies. You may have eviction moratoria or eviction or tenant disputes that delay your eviction. There's actually other foreclosure complications that have arisen recently, where there's been recent challenges to the commercial reasonableness of a foreclosure, which may require you to send more notices, do more publication, or send more advertisements out. So either way, it is a costly procedure. What about from the borrower's perspective? From the borrower's perspective, they have an asset. They have a concern that the asset is going to deteriorate in value. They may take a significant credit hit. Clearly, if in fact there is a foreclosure, there may be a controlled sale that they prefer. If it's a going business, they're going to make more money, more return for you if they can do it at their own pace with a new buyer. There are tax implications, 1099 issues. Foreclosure is a very extreme tax issue, but certainly forgiveness or restructuring of the debt can also be of a concern. So let's go on to the next slide, where we talk about what are the preliminary considerations and steps you as a lender need to think about. First of all, it is all about due diligence. You need to manage the loan workout process, know who in your departments are handling it so you can coordinate the response. You're going to need to look at every single loan document in your file, all of the borrower's documents. You're going to want to conduct a collateral review. Make sure that that lien is fully perfected. Make sure you're pulling a title to look at any IRS liens, any other junior liens that you're going to have to deal with. You're going to want to make sure that your loan document file is complete. Do you have fully executed documents of everything? Do you have evidence of recordation of the documents where necessary? What about agreements? Are there some agreements that could affect how you're going to deal with the borrower? You're going to want to maybe do field audits of additional collateral, accounts receivable, equipment may be part of your collateral. You're going to want to look at that. What covenants have been breached? Are they technical or more material? Are there activities that you've allowed to slide, letting a borrower sell their assets outside of the ordinary course of business? How about distributions of profit? Have you been letting those slide when in fact your credit committee is going to have a problem with that? So you're going to want to look closely at all of that. Are there any disputes? Do you have lender liability risks that could derail any activities you're going to move with moving forward? Is a loan recourse? Are there guarantors? What type of guarantee have you been provided with? Are there any carve-outs, fraud and misrepresentation, where you could leverage that guarantee to cover more financial ground? How about evaluation? Do you have a current appraisal? Is it looking at foreclosure value versus fair market value? What position are you in? Who needs to approve? Do you have junior lien holders that may take an interest, may have a lot of say in what you're going to be able to do? What improvements are necessary to make the property sale ready? If it's a construction loan, what is the status of funds advanced? Are there subcontractor issues? How far along are you in this project? Is the borrower on schedule? And then how about getting the borrower's attention? How do you do that? Borrowers certainly don't want to come to you necessarily. You may need to get their attention, but do your homework first. You want to first see what are the organizational documents the borrower has that you have in your file. Who are the parties on board on the plan? Who needs to provide any kind of approvals? Request the borrower's financial, request their disaster recovery plan, request their business continuity plans, and study them. Look at their financials. The integrity of the financials and their accuracy are going to be paramount to whether or not you're going to be able to work something out. Assess any business threats, capabilities, and assets. Then finally, you want to get the borrower's attention. How are you going to do that? You're going to look at what is the viability of the borrower's business plan? What is their current environment? Are their expectations adequate? Are they reasonable? You're also going to look at the projections that they've given you. Are they reasonable? Do they make sense? And then finally, you're going to want to make sure that you have a pre-negotiation agreement. Very important before you start down a path of negotiation. You're going to want the borrower to acknowledge the default, to affirm the loan covenants, to make sure that parties agree they're entering into the negotiations in good faith, but that any agreements are not enforceable unless and until they are formalized in a written agreement. The last thing you want is the borrower to look at preliminary discussions as being a definitive agreement. You also want to preserve your rights and remedies under the loan documents. So finally, you want to take action. You want to trigger default provisions. You want to send potentially a notice of default. You may potentially want to call that guarantee. You may, though, want to delay a bit until you can get the borrower into some discussions. You may want to contact or visit the borrower. You may want to terminate drawdowns, increase interest rate, or look at the default rate, all of which can get the borrower's attention. And then you want to look at enforcing provisions. You may want to demand protections. You may want to look at that assignment of rents. You may want to adjust reporting requirements. There are a lot of ways that you can certainly get the borrower's attention. So now let's move on to the next slide and talk about foreclosure alternatives. You're going to first look at what is the nature of your interest. Is it a fee interest or a leasehold? That is going to determine what way you may be able to go. What about a note sale? Investors typically buy debt, sometimes in a single purchase or sometimes in bulk. What is available to you to be able to reach out to investors? What are they going to be looking for? They're going to want to make sure the note is negotiable, it's enforceable, every allonge is in place. So you're going to make sure you're studying all of that to make sure that when the time comes that you can move forward with the note sale. If there's any disputes, minor or major, you want to revisit those to make sure you can resolve those relative to the note sale. You may want to look at the leases. For most of our clients, of our customers, the primary source for repayment of a loan in a commercial lease is generally leases. You want to look out, you may really want to decide, you want to engage a workout consultant, particularly if there is going to be any workout relative to lease or restructuring, because you do not want to mix yourself into the borrower's business. You want to stay separate, you want to stay apart. So a consultant can be very valuable as you look through a restructuring of the leases. You want to look at, are there any tenant bankruptcies? Are there any other creditors? Are there any government consents? Are there some government leases that you're going to need consent to restructure? Are there public development agreements or rights that may be impacted? Are there guarantees of the borrower? Is there a letter of credit? What is the status of any security deposit? Have the leases been assigned or subleased? Has there been any sublease? Is the original tenant still liable? So those are all the types of things that you're going to actually want to look at as you move through doing a lease restructure. And then generally, let's talk about loan workout modification. There really are few market standards for a loan workout modification. There's generally not a typical modification because most of the time, when you come to work out a loan, the loan varies from borrower to borrower. The terms are different. The borrower's position is different. So you really are going to end up many times customizing your workout. But there are some things that you want to focus on. It's all going to be about maximizing the recovery, looking at the assessment of the payment and the cash flow from the sale or the leasing of the property. What I'm going to remind you is the critical importance of putting everything in writing. Any loan modification workout, no matter what shape it evolves to, must be pursuant to a written agreement. You want the borrower to acknowledge the amount of debt, that the lien is perfected, that there are no claims or the tenant or the borrower needs to waive claims prior to the date of the agreement. You want the right to accelerate without further notice. You're going to want the borrower to acknowledge that the modification or workout was for adequate consideration to make sure that there are no issues with that. You want drop dead provisions. You want a termination of any modification as a provision of the written agreement. And now you're going to look at what type of options may those written agreements cover. What about a short-term solution? That may be, maybe you want to loosen those financial covenants a bit. Maybe you want to shorten the period of time for repayment. You may want to increase the interest rate. You may want to reduce the interest rate or the payments for a temporary period of time. If it's a more serious loan issue, you may want to restructure the loan terms and covenants. You may want to extend the term, amortize the payments over a longer term. Adjust or suspend the covenants. Think about a balloon payment at the end of the term. Think about equity sharing from the borrower if their plan is ultimately to dispose of the property. You may want to amortize those payments in a different way. You may want to look at more collateral. Is there additional real estate you can take? Is there accounts receivable, stock? Is there a letter of credit? Is there key man insurance that you could take an additional collateral interest in to give you more financial wherewithal? So those are the types of things that you want to look at when it comes to loan modifications. But there's a couple of other significant types of modifications I just want to talk about. Forbearance is very popular right now. We saw it in the residential space, and now it's coming into the commercial space as borrowers scramble to negotiate tenants out of a lease that maybe is not working for them. Maybe there are payment defaults. So we're seeing a lot of that. The real estate market is slowly coming back to life. But there may be some in some states where it just has not revived enough. So you may look at forbearing for a special period of time from exercising your rights of default. You're going to acknowledge that the borrower is still in default, but you want to provide a date certain by which forbearance will end. You want to make sure you spell out the nature of the current default and make sure clear that further defaults or a different default is going to terminate that forbearance agreement immediately. If there are actions or rights under the loan documents that you wish to forbear as part of that, in other words, to stop, maybe it's construction drawdowns, lease extensions, you want to make sure that you cover that in your forbearance agreement. And then you may want to look at deferring those payments you're forborne into the end of the loan term. You may want to waive several payments as a good faith effort. So there are lots of different ways that you can work out a loan and try to bring it back into full performance. So now let's move to our next slide on foreclosure alternatives, asset retention. Assumption assignment of mortgage is very popular in a number of states. So you may want to be willing to work with the borrower depending on the credit worthiness of the party to whom who wants to assume the mortgage. You may want to look at suit on those guarantees. There may be collateral securing the guarantees that you may want to pursue. There may be some equity participation, which I mentioned earlier, that you may want to formalize. There may be additional collateral that can be brought to bear. The borrower may want to bring in additional partners. You may want to validate their financial wherewithal, which may help the borrower see their way through to put together a stronger financial package for you. And then finally, you may want to consider making a demand on that assignment of rents. The procedure is typically governed both by the contract, the assignment of rents generally recorded, and by statute. In some states, it's quite simple. You make demand on the owner, you begin to collect rents. In other states, especially if there is a pending foreclosure action, you may have to bring a motion for sequestration of rents. You may have to appoint a receiver, depending on the jurisdiction, depending on the risk of you becoming a mortgagee in possession. You may also want to consider whether or not, if the borrower is not cooperating, if they're ignoring your demand, whether you now want to move to make a demand on the tenant. That does carry some risk, because then the tenant knows the borrower's in default, the borrower is struggling, and that may encourage them to stop paying rent. So you always want to look at that carefully before you immediately trigger moving in to get the tenant's attention. So that is really an assignment of rents, however, can be a significant tool in your toolbox to be able to help you resolve that loan. So that ends my presentation. And Regina, I'm going to turn it over to you to talk about other alternatives, asset liquidation.
Well, thank you, Julie. And thank you, Connie, for that nice introduction earlier. I'm really happy to be here today and discussing these topics with you, at least from a 40,000 foot level. There is much information here, so let's get started. Sometimes it will not be possible to retain that asset. And yet, for many reasons, it may still be better to avoid foreclosure. This is when you start looking at your asset liquidation. There is due diligence involved in these options as well, similar to retention. The most important three are your title search, the current status of the property, and recognizing whether there is equity in the property. The title search is essential. It is absolutely essential that you understand the other encumbrances on the property. Most importantly, how many mortgages and your position in them. It's also noteworthy to see any municipal liens, real property tax liens, special assessments, etc., because these will need to be paid regardless of priority. They survive foreclosure. They must be addressed in all retention options and must be paid if the asset is liquidated. The current status of the property, whether there are current tenants, property violations, etc., is very important, both to the viability of the sale and to how secure your lien is. And then finally, knowing whether there is equity can also have a material effect on your decision. If there's plenty of equity in the property, your option pool is larger, so to speak. So the first option is a facilitated sale. Now, by this, I mean simply that it's a sale that everyone is aware of, everyone's amenable to, and it otherwise works pretty much as a standard commercial sale. Like Julie noted earlier, this gives you a better opportunity to realize the full value of the asset. This works best if there's plenty of equity in the property and the mortgage holders are involved, but may or may not be controlling, as the thought is that everyone will be paid off in full. There is extra attention because timing is a key factor. Obviously, a lender is agreeing not to foreclose during this time, so the lender can have more say as to timing, price, broker selection, etc. The best practice here is to memorialize these terms among the parties so that you are all on the same page. Your second option is a short sale. Now, a short sale is when a property is sold for less than what is owed on it, and the lender or the lenders do not get all of their money back. In these situations, the property is underwater. For this, it is very, very, very important that you know and understand your title, because all of those players, whether they be senior to you in lien or junior to you in lien, need to be at the table. It is not mandatory for a lender to accept a short payoff. So each secured lien holder must agree to the terms, and the sooner all are involved, the better. There are some advantages to a short sale, namely it avoids the foreclosure, and like a facilitated sale, it allows a certain amount of time to plan. It's typically less of a loss for the lender than through foreclosure, and allows any junior lien holders to potentially obtain something from the proceeds, even if not in full. But this can still be an attractive option if it exists, since from their secured interest will be extinguished completely if a foreclosure sale goes through. It's important to note, it does not necessarily waive a deficiency. So other options to collect on the debt may exist following the short sale. These are typically negotiated during this entire time. There are other key pieces of information you may want to consider, like whether if there is an SBA loan, an SBA junior lien may increase the attractiveness of a short sale, as the SBA right of redemption lasts 1 year, and that leads to uncertainty following a foreclosure. Is there a business associated with the sale, which makes it more valuable? Are there tenants in the property, and are they paying? Do you have the tenant estoppels available for potential buyers? Are there other factors in the area which may affect the timing and the price? Remember, in this, time is of the essence, and you don't want any surprises at the 11th hour. So the more information, cooperation, and focus you have during this time, the better. The third option is a deed in lieu. The proper name for this is a deed in lieu of foreclosure. And it's just that. The owner of the mortgagor deeds the property to the lender mortgagee instead of going through the foreclosure process. This really should only be done in certain circumstances. In particular, marketable title already exists, meaning there is one secured lien, the grantee of the deed in lieu, and there are no juniors to reckon with, because the deed in lieu will not wipe out any junior liens. It conveys the ownership of the property. Most jurisdictions require consideration alongside a deed in lieu. So there's typically forgiveness of the debt in return for the property. In the right circumstances, this is win-win because the borrower ends up free from the debt and the lender has marketable title for the property without the time and expense of foreclosure. What is important to remember in this situation? Leases remain intact, but the new owner does not hold the contract with the tenants. So you want to make sure this is addressed prior to finalizing. The lender and the borrower must work together to put that information in order. So a copy of all of the leases, the ledger information, including the status or the transfer of security deposits, the tenant estoppels, and importantly, getting the SNDA from the tenants. With the SNDA, both parties, the lender, the new owner, and the tenants contractually recognize each other. And as a result of this, the tenant pays the rent due right to the lender on time. It saves time, it saves money, and it helps when everybody understands the players. Additionally, this can also specifically insulate the new landlord from actions and liability of the old landlord. But under any circumstances, whether you can get all of this information or not, you need to make sure that these aspects are addressed. So those are the three main methods to liquidate the asset for the benefit of the parties. There are, however, a few key issues which can frustrate those efforts and cause delay, disruption, or derailment. So the first one there is an uncooperative borrower. In order to be successful with any of these options, all sides must be cooperative. You all have to want, at the end of the day, to avoid the foreclosure. The borrower in bankruptcy. This will cause an unavoidable and hard stop pending the resolution of the bankruptcy. Depending on the type of bankruptcy, this can have an effect on whether the property can even be sold, the amounts due, and the terms of repayment of the loan, even the price of the asset. Likewise, a tenant filing for BK can affect a sale. It will not force you to a hard stop, but depending on the size and the value of the tenant, it could render the property valueless. So you cannot evict the tenant without court approval in the BK. And again, depending on the chapter, you may or may not be able to obtain that approval. Though it wouldn't stop a sale, it could have a very chilling effect on the price of it. Notices of violations or condemnation. You cannot outrun the government. And if the property has been condemned or is threatened to become condemned, it might sound obvious, but you're going to have a very difficult time getting top dollar in a potential sale. Continuing down this road, receiverships. There are two types of receiverships that can affect you. The first is a court-appointed tool that is actually designed to assist creditors to recover funds in default and can help troubled company to avoid bankruptcy. It can be a method some choose to avoid foreclosure. I am not personally a huge fan of it in plain vanilla cases, and I will tell you why. First, they are very expensive, and the receiver gets paid first. Second, you lose control. The receiver is reporting to the court, not to the creditors, not to the lenders. So the receiver decides the priority of payment, which may or may not include you. The receiver decides and has the option of deciding certain assets that must be shed for the benefit of the estate of a whole as a whole. And it might just be your security that it sheds, which leaves you as a creditor, but no longer a secured one. And it is time consuming, very time consuming. Secondly, though, additionally, in some jurisdictions, a property can be put into receivership for code violations. For example, in Massachusetts, a receivership can be used to enforce the state sanitary code, and it places the management of a distressed building under the control of a judicially supervised receiver when the owner or interested parties are unable or unwilling to make the necessary repairs to return the building to code compliance. Again, it is expensive. And again, the receiver gets paid first. Again, it's out of your control at this point. And if the receiver does decide to sell the property, it is subject to the receiver lien and the receiver lien only, and is free and clear of any other lien once sold. This is something you absolutely want to avoid. And so it is massively important to avoid the appointment if possible by repairing the property. But if a receiver is appointed, to work with the receiver to the absolute best of your ability to repair it. And finally, environmental issues. These often arise during the due diligence period that the purchaser has in a potential sale, and it can quash it entirely months after the purchase and sale agreement has been signed. It involves the known, the potential, and the contingent environmental liabilities and obligations associated with a parcel of property to be acquired. It extends even to the potential for contamination to migrate to the property from other locations. So the questions here are there environmental issues? By whom do they need to be addressed? Was a baseline done at your borrower's time of purchase? Will it survive an environmental phase 1 or phase 2 by a potential purchaser? If it fails, there are severe consequences to either the price or the viability of the transaction entirely. So obviously there are as many special curveballs to be thrown as there are pitchers to throw them, but these cover some of the most common derailments with the biggest impact. So thank you for attending. We realize we covered many topics at a high level. We definitely want to be respectful of your time, but we do have a couple minutes for questions. Do we have any questions, Connie?
Thank you, Julie and Regina. We do have a few questions from the audience today. The first question is, what conditions would compel a lender to choose to foreclose?
Sure, I can take that. As Regina mentioned, one of the most compelling reasons is a very uncooperative, unresponsive, not available borrower, and potentially their guarantors as well. That is really going to stop dead in its tracks many of the different alternatives that we provided to you today. Also, in some jurisdictions, you may have falling real estate values where it is time to move forward, to at least go forward with foreclosure to secure that value of the property. And then it may be that despite all of your efforts, you had a cooperative borrower, you went through a loan modification, maybe there was a short sale that was considered that didn't work out. As Regina said, you've got other junior liens who are not willing to work with you on a deed in lieu or other. So there are going to be instances where your only alternative at the end of the day is foreclosure. But certainly, if you at least have pursued other options to start with, you will feel more confident going forward with that last resort, if you will.
Great. Next question. What strategies can a lender use to work with the municipality to resolve or mitigate the effect of code violations?
I'll take that. That is a great question because it falls into that receivership issue. And here's the thing, unless you are in and out of City Hall in a good way on a daily basis, you want to use counsel. And specifically counsel who's experienced at the municipal level. The property inspectors and the enforcement officers are a finite group of people, and they'll often give you the benefit of the doubt based on the word of your counsel if they know them. For example, our attorneys are frequent flyers in the municipality. They know the proper contacts, and when they work, they can give you a better idea of what to expect and the deadlines the particular officials will seek. And remember, there's many ways this can go, from written citations to a daily penalty if ignored, resulting in some cases of hundreds of thousands of dollars in penalties, to full out receivership. So you want to present your best side at all times. Now, if you do have these issues that you have to deal with, you need to make a plan. So you need to get a list of the needed repairs, identify especially the low-hanging fruit, so to speak, the most urgent ones that you need, the ones that affect the habitability or are deemed dangerous, the easiest, because then you set the plan for repair and you set deadlines for completion. You share that with the municipality and you stick to that plan, and you communicate often as possible, because you tell them immediately if something changes or gets in the way. Let them know the backup or the remediation and the new deadline. The end goal of the city is for safe property that maintains or supports the property value of that area. And most are willing to work with you as long as they see continued good faith efforts on your part. So setting that plan, sticking to that plan, and communicating about the plan is your best bet.
Thank you, Regina. Our final question for the day is, how can a lender effectively bring a guarantor into the discussion?
I can take that, Connie. That's another excellent question. I touched on it briefly about guarantors as I rolled through my presentation, but it's a great concept. Your guarantor or one or more guarantors in a commercial loan can really act as an ace in the hole. What you really want to start with on leverage is make sure that the guarantor actually knows what's going on. So many times we find that the guarantor is oblivious, is not being kept in the loop by the borrower. So you really want to work with the borrower to bring that guarantor in. And depending on the type of guarantee it is it a full guarantee or a partial guarantee, you can leverage that. You can really bring them to the table, particularly if there is collateral that's securing that guarantee. You can look to focus on that, send a demand to the guarantor separate from the borrower, so they know you are looking directly at them. So there are lots of ways to bring that guarantor to the table, and they can really become, in some respects, a partner with you to work with that borrower to bring all of the assets available to help you resolve that loan.
Okay, that was our final question for the day. Thank you, Julie and Regina. This concludes our webinar for today. We thank everyone for attending our webinar today, and we hope you have a great day.